So we were talking about non-competition agreements, and we said obviously there is a potential for abuse there because it's an agreement that doesn't come into play until after the employment relationship is over. That means that your former employer could take a monopoly over your services forever, in perpetuity. And so as we shifted to this freedom of contracts idea, the law stepped in to say, no, we're going to restrict that absolute ability to restrict employment. We're going to limit the ability of an employer to restrict his employees from competing against him. So the common law approach, which we refer to this, and really this is the basis for all non-compete law in the country, all based on the common law. Even in those states, about half of the states have a statute, but those statutes all tend to be based on this common law approach. So how does the law treat these non-competition agreements? Well, the first thing that the law looks at is it's going to ask the question, when a court decides whether to enforce an agreement or not, it will ask the question of, does the non-competition agreement serve a legitimate business purpose? Non-competition agreements are not meant to punish the former employee. Instead, we permit non-competition agreements to the extent that those agreements prevent unfair competition. So we're going to limit competition, but only that competition which would be unfair. So taking the idea of customer lists, for instance. If you take the customer list with you, then in fact you are unfairly competing with your former employer. Now the common law, when it was trying to decide this issue of how do we enforce, or if we enforce, non-compete agreements, the common law realized that there's a lot of interest at play that have to be balanced in order to decide what agreements we will enforce and which we won't. And first of all, we take into account the interests of the employer. The employer has invested time and money in finding this employee. The employer has likely invested time and money and energy into training the employee. And therefore, for those purposes, we want to encourage employers to keep doing these same things. And we want to protect that employer from unfair competition. So whenever we look at the question of how much we'll enforce a non-compete, the first thing we look at is, does it represent the interest of the employer? But we also have to worry about the interests of the employee, meaning we have a person who's willing to work, who's ready to work, and in fact may have a job available to them. And therefore, is it fair to allow a previous employer who's no longer paying this former employee, is it fair to allow that employer to restrict the employee from doing a job, from earning a living, from putting food on the table? So whenever we look at enforceability, we also have to look at the idea of what protects the employee. And then there's this third interest that we also have to focus on, the interest of society. What is good for society as a whole? Yes, society wants to prevent unfair competition, but society also wants people to be able to work. We have an economic and social system based on employment, so it seems very strange that a government agency would restrict a person from going to work. And of course, if you restrict that person from working, that person is much more likely to seek the assistance of society as a whole through unemployment or through any sort of needs-based request to the government. So society wants people to be working. Society wants people to be able to buy things. You know, if you're a salesperson, you know, your job is selling groceries, you want those people that have jobs to keep working. You don't want that person to go sit home for 6 months or a year or 2 years just because a previous employer had been granted this monopoly over him. So whenever we take into account, are we going to enforce a non-competition agreement or not, we look at these three interests and try to strike a balance between them. Now, when we talk about a legitimate business purpose, again, this is the threshold question for a court to look at when deciding whether to enforce a non-competition agreement or not. Is there a legitimate justification for the agreement? The agreement cannot exist solely as a means to punish the former employee or to prevent a worker from seeking a better job somewhere. So, traditionally, there are two primary interests that are seen as legitimate justifications for a non-compete agreement. And the first of these is protecting the goodwill of the business. Now, goodwill is a sort of fuzzy concept. I'm sure you've heard it discussed in your other business classes. But goodwill, the shortcut to thinking about what is goodwill, what is a business's goodwill, it's you take the value of the business, what is this business worth, what could you sell this business for, and then you subtract out the assets of the business, the physical assets, the intellectual property assets, whatever the value of those things are, and then what's left over is called goodwill. So that's things like relationships. You know, when I go to a stockbroker, for instance, I likely have a relationship with that stockbroker. But the only reason I wound up at that stockbroker was I saw commercials on TV for Edward Jones. And so I am not really a client of this particular stockbroker. I am a client of the firm. And it was the firm that was responsible for bringing me there. Their advertising, their word on the street as to if they were good or not. So those are the kinds of things that make up goodwill. You have to be able to protect an employer's relationships because that's a legitimate justification for a non-competition agreement. Now, the other aspect which we recognize as a justification is protecting the trade secrets of the business. We are concerned about protecting trade secrets. And as I mentioned previously, trade secrets are more than simply technical matters or patents or processes. Instead, trade secrets can also be things like customer lists or price list or future expansion plans. Those are all trade secrets of the business, those confidential things that if they were released would cause harm to the business. So we want to protect those matters. We want businesses to be able to have those matters confidential, kept confidential. So this is another justification for protecting the trade secrets of the business. So on your test or in real life, if you have to decide whether an employment agreement is enforceable or not, look to see, does it meet one of those two interests? Does it serve one or both of those interests? And when it comes time to draft a non-competition agreement, which you'll have to do as part of your writing assignment, is we want to look at, we want to say, what is the purpose of this non-competition agreement? What is this non-competition agreement doing? And be able to cite one of those two primary interests.